This yacht wasn't frozen because of what it did. It was frozen because of who controlled it. No arrests were made. No charges were filed. But U.S. authorities moved anyway, using jurisdiction most people don't know exists. The yacht was worth over $100 million. It was registered offshore. It was owned by a company that didn't appear on any sanctions list. And yet it couldn't move. This is how modern sanctions enforcement works. Not through headlines but through systems. Please like and subscribe to this channel. Sanctions used to be symbolic. A name on a list. A frozen bank account. A public statement. But over the last decade that approach changed. Authorities realized that targeting individuals directly wasn't enough. Money could be moved. Accounts could be restructured. Legal names could be replaced. Physical assets, however, couldn't disappear. And among those assets, yachts became a priority, not because they're symbols of wealth, but because they're logistically vulnerable. A superyacht requires constant payments. Insurance, crew salaries, fuel contracts, port fees, maintenance schedules. It cannot operate in isolation. And that dependency is what makes it enforceable. Bank accounts can be closed and reopened under different structures. A yacht, once docked, is visible, trackable, tied to a global network of service providers who are subject to compliance laws. This shift in enforcement didn't happen overnight. It accelerated after geopolitical tensions escalated and coordinated sanctions were imposed on Russian elites and their financial networks. As those sanctions expanded, U.S. and allied authorities moved beyond targeting individual names and began reviewing the infrastructure that sustained luxury. Yachts, private jets, and rare maritime vessels entered the enforcement pipeline, not because they represented crime but because they represented control. And control, under sanctions law, is what matters. In this new enforcement environment, visibility became a liability. High-value assets that once signaled status now signaled exposure. Yachts that moved through Western ports, refueled at Allied harbors, and relied on American insurers were no longer protected by offshore registration or corporate ownership. They were pressure points, and this particular yacht was one of them. The vessel itself was extraordinary, not because of luxury features but because of scale. It was over 300 feet long. It required a crew of more than 40. Its estimated value exceeded $100 million, placing it among the rarest superyachts in operation. But on paper, nothing about it appeared illegal. It was registered under a corporate entity based in a jurisdiction commonly used in maritime law. It was insured through recognized providers. It was managed by a professional yacht services company. To casual observers, it was compliant. To investigators, it was a pattern. Because yachts at this level don't exist in isolation. They require funding streams, decision-making authority, and long-term financial commitment. And those elements leave traces. This yacht had docked in multiple Western ports over several years. It had been refueled, serviced, and crewed through providers operating within U.S. and allied jurisdictions. Each interaction created documentation. Each transaction could be reviewed. And as sanctions enforcement intensified, those records became part of a broader investigation, not into the yacht itself but into the network surrounding it. What investigators reportedly found was a pattern of control that didn't align with the corporate ownership structure. The company listed as the owner appeared to be a single-purpose entity. It had no other operations, no other assets, no clear revenue source beyond the yacht itself. That raised questions. Who funded the purchase? Who approved major operational decisions? Who ultimately benefited from the yacht's availability and use? Those questions couldn't be answered through registration documents alone. But they could be answered through financial tracing, service contracts, and coordination with allied enforcement agencies. Over time, a picture reportedly emerged. The yacht was linked, directly or indirectly, to an individual within a sanctioned network. Not through ownership on paper but through control in practice. And that was enough. Please like and subscribe to this channel. Superyachts are rarely owned by individuals. Instead, they're held through corporate structures designed for privacy, liability protection, and tax efficiency. This is standard practice in the maritime industry. It's legal. It's common. and it's incredibly effective at obscuring beneficial ownership. A typical structure might look like this. The yacht is registered to a company in the British Virgin Islands. That company is owned by a holding entity in the Cayman Islands. That entity is controlled by a trust in Jersey. The trust is managed by nominee directors who have no personal connection to the beneficial owner. On paper, the trail ends at corporate entities and legal representatives. But sanctions enforcement doesn't stop there. Because ownership and control are not the same thing. Ownership is a legal designation. Control is operational reality. And investigators focus on control. They examine who pays for the yacht's upkeep, who signs off on crew contracts, who approves travel itineraries, who has access to the vessel. These aren't always documented in public registries, but they create patterns. A wire transfer from a specific bank, a contract signed by a particular attorney, a crew member hired through a connected firm. Individually, these might mean nothing, but collectively they build a case for linkage. In this instance, authorities reportedly identified repeated financial and operational connections between the yacht and an individual within a sanctioned network. The funding for maintenance appeared to flow from accounts tied to that individual. Key decisions about the yacht's movements were reportedly made by advisors connected to that individual. The vessel's availability aligned with that individual's known travel patterns. None of this proved ownership in a legal sense. But under sanctions law, proof of ownership isn't required. What matters is beneficial interest and effective control. If an individual can use an asset, benefit from it, or direct its operations, then that asset can be treated as if it belongs to them for enforcement purposes. This is the framework that allowed authorities to move forward. Not because the yacht was registered in the wrong name, but because the evidence suggested it functioned as if it belonged to someone within a sanctioned network. And that was legally sufficient. The United States did not need the yacht to be American flagged to act. Jurisdiction can be established in other ways. Through the use of U.S.-based financial institutions. Through U.S. dollar transactions. Through American service providers. Through cooperation with allied governments and ports. Once any of those thresholds are met, U.S. authorities can move under sanctions law. And they don't need to file criminal charges to do it. This is critical to understand. Sanctions enforcement is administrative and financial, not criminal prosecution. It operates under different legal standards. It doesn't require proof beyond a reasonable doubt. It doesn't require arrests or indictments. It requires evidence of linkage and jurisdiction. In this case, both were reportedly present. The yacht had used U.S.-based service providers. It had conducted transactions in U.S. dollars. It had docked in ports where American financial infrastructure was involved. That gave U.S. authorities the legal basis to act. The enforcement action itself was handled quietly. There was no public announcement in advance. No dramatic raid. No media event. Instead, authorities reportedly coordinated with the port where the yacht was docked and issued a freeze order. The yacht was immobilized. It couldn't be moved. It couldn't be sold. It couldn't be transferred. Its bank accounts were restricted. Its insurance policies were flagged. Its service contracts were placed under review. This is what a freeze means in practice. The asset remains in place but it can no longer function. And that creates immediate pressure. Because a frozen yacht still costs money. Crew wages must be paid. Port fees accumulate. Maintenance schedules continue. Insurance premiums are due. But the funds to cover those costs are now restricted. The freeze doesn't just stop the yacht, it drains the financial network around it. And that's the point. Authorities didn't seize the yacht immediately because a freeze is often more effective. It preserves the asset's value. It allows time for further investigation. It creates financial pressure without escalation. And it signals seriousness without finality. If evidence changes, the freeze can be lifted. If cooperation occurs, negotiations can begin. If enforcement strengthens, seizure remains an option. The freeze is a tool of strategic patience. And in this case it worked exactly as intended. Once a yacht is frozen, the clock starts. Every day it sits immobilized is another day of accumulating cost. Crew salaries, maintenance contracts, port fees, insurance, fuel storage, security. These expenses don't pause because the yacht is frozen. They intensify. And the frozen entity has limited options. They can challenge the freeze in court, but that process takes time and often requires disclosing information they prefer to keep private. They can attempt to negotiate, but that means engaging with authorities and potentially exposing the beneficial owner. Or they can wait and watch the financial pressure build. This is why freezes are effective even without seizure. Time becomes leverage. The longer the yacht remains frozen, the more expensive it becomes to maintain. The more complicated it becomes to resolve. The more likely it is that someone within the network will make a decision authorities are waiting for. In some cases, frozen assets are eventually released. In others, they're permanently seized. In many, they remain in legal limbo for years. But the outcome isn't really the point. The pressure is, because this yacht is not unique. It represents a broader shift in how sanctions are enforced. Authorities are no longer focused solely on individuals. They're focused on the infrastructure of wealth, the mechanisms that sustain luxury, the systems that preserve anonymity, the assets that require constant cooperation from the global financial network. In that framework, yachts are not protected by offshore registration or layered ownership. They are exposed by their dependence on Western systems. And this freeze is one example of how that exposure is used, not dramatically, not publicly, but effectively. In modern sanctions enforcement, luxury is not insulation. It's evidence. And that evidence is increasingly traceable. Please subscribe to this channel if you haven't. See you in our next video.